What is a terrorist document according to Section 58 of the Terrorism Act 2000? What defences are available if arrested or taken to court for a Section 58 offence? What should you do if arrested or charged with Section 58 offence? What are the maximum sentences for Section 58 offence? And what observations and criticisms have been made about the Section 58 offence? This is a community legal education presentation. My name is Nissa Hafizi, I'm a solicitor, and here's 9 questions answered about Section 58 terrorism offence, possessing a terrorist document. 1. Why possession of terrorist document was made a serious terrorist offence? Section 58 is a popular terrorist offence used by counter-terrorism police and prosecutors to arrest and charge people. It is known as a precursor offence, which basically means no act of violence needs to be committed by the person to breach the criminal law. The Section 58 offence is designed by government and law enforcement agencies to stop a person from accessing and collecting a terrorist document, stop a person being seduced by a terrorist document and turning their unhealthy interest into an act of terrorism, and generally stop the spread of violence by making it an offence to collect, make and or possess terrorist documents. Section 58 offence is sometimes compared to possessing indecent images. 2. What is the definition of a terrorist document according to Section 58? A terrorist document according to Section 58 is information of a kind likely to be useful to a person committing or preparing for an act of terrorism. And in case law, this has been interpreted as information of practical assistance to a would-be terrorist. Examples of terrorist documents covered by Section 58 convictions include a person who downloads a Daesh-produced film showing how to carry out a knife attack, a person who had a manual entitled Poor Man's James Bond that included advice on do-it-yourself explosives and unarmed combat, and a person's possessing bomb-making equipment document. Other recognised terrorist documents that feature in terrorism convictions include the Anarchist Cookbook, Make a Bomb in the Kitchen of Your Mom, the White Resistance Manual. What is not a terrorist document according to Section 58 includes material that glorifies terrorism, that potentially is another terrorist offence of Section 1 encouraging acts of terrorism, or innocuous documents in the possession of a person for illegal purposes like the A to Z map of London, which may be used to commit an act of terrorism. This would be an offence covered by Section 57 of the Terrorism Act 2000, possessing an article for terrorist purposes. 3. What 3 offences are created by Section 58? Section 58 creates 3 offences. 1. It is an offence for a person to collect or make a record of information of a kind likely to be useful to a person committing or preparing an act of terrorism. 2. It is an offence for a person to possess a document or record of a kind likely to be useful to a person committing or preparing an act of terrorism. And 3. It is an offence for a person who views or otherwise accesses by means of the internet a document or record containing information of a kind likely to be useful to a person committing or preparing an act of terrorism. This third offence, nicknamed the Medusa offence, was created by the Counter-Terrorism and Border Security Act 2019, which according to the government is designed to close a gap and would make an offence where a person transiently accesses information on the internet, for example by streaming a video or viewing a website, without making some kind of permanent record. 4. What the police and prosecution need to prove in a Section 58 case. One striking feature of Section 58 is that the police and prosecution do not need to prove that a person possessed the record or document for an actual terrorist purpose. Instead, all the prosecution needs to prove a Section 58 offence is 1. The person had in their possession a document or record. 2. The document or record was information of practical assistance to a would-be terrorist. 3. And that person knew that he had the document or record and was aware of the nature of the information it contained, and that the person did not have a reasonable excuse for being in possession of that document or record. 5. What defences are available? Section 58 provides a number of statutory reasonable excuse defences. These are: person did not know or had no reason to believe that the document or record contained or was likely to contain information likely to be useful to a terrorist, or the person's actions or possession was for the purposes of carrying out work as a journalist or academic research. It's important to know that the list of reasonable excuses are not limited to the above. Any reasonable excuse defence put forward by the defendant should be objectively reasonable and verifiable to succeed at trial. 6. What should the suspect do at police interview if arrested for Section 58 offence? The suspect at the police station interview may want to put forward a reasonable defence excuse to persuade the counter-terrorism police that they have a defence and it would not be in the public interest to pursue a prosecution, and that there would not be a realistic prospect of a conviction. The suspect should always have a specialist solicitor who deals with terrorism cases at police interview. 7. What should a defendant do at trial if charged with a Section 58 offence? The defendant would need to carefully consider any reasonable excuse defence available with specialist legal advice, and remember, if any defence is put forward, the prosecution will need to disprove it. Ultimately, it would be up to the jury to decide guilt or innocence. 8. What kind of sentences are available for a Section 58 offence? The maximum penalty for all 3 Section 58 offences is 15 years in prison. 9. What observations and criticisms have been levelled at Section 58 offences? 5 are mentioned here. 1. There's little published guidelines of documents equating to an offence under Section 58 that is widely known by the public. Some argue that there should be public list of Section 58 material which, if a person collects, makes, possesses or views, would be an offence. Others argue differently, that such a list is unnecessary as it would be obvious what a document useful to a terrorist would be. Having said that, many documents which feature in terrorism cases are widely available on the internet, and many people are unaware of the serious consequences of simply viewing such offending documents. 2. As a person can commit a Section 58 offence without a terrorist purpose in mind or terrorist motive or terrorist intent, some critics argue that this makes it too easy to prosecute individuals who have no illegal or terrorist purposes in mind when possessing the offending material, and places too much discretion in the hands of a prosecutor as to who to take to court and who not to. 3. Others argue that Section 58 is so widely drawn in its scope and the statutory list of statutory reasonable defences excuses limited, the offence can be potentially criminalise the following: the curious, or those who seek to review such terrorist documents to challenge it and other propaganda in it, or those who have a pop-up page on a computer screen but have not viewed the document, or a person who accesses a magazine or a book where the majority of the pages and chapters are political or religious in nature, or where 1 or 2 pages or chapters fall foul of Section 58 and have not been viewed. 4. Some observe the reasonable excuse defence provides insufficient safeguards, being limited, unclear and lacking in any certainty for the public. And finally 5. A more fundamental criticism of Section 58 has been levelled in this way. The inherent claim is that viewers will either be seduced or have their will overwhelmed by the inevitable power and persuasion of the terrorist messages. Yet other outcomes are statistically more likely by far. Thank you for watching. Please subscribe so you can watch more videos in this series and many more. Please speak to a solicitor if you need legal advice, and may the justice be with you.